Okay.
No.
All right. Good afternoon, good evening. I'm Amy Bach, and I'm coming to you from San Francisco. And I am very pleased to be able to bring you a webinar today that will address one of the most challenging aspects of losing one's home in a disaster for about 2/3 of people who do lose their homes. And that is finding out after the fact that, contrary to whatever representations were made when you bought your home insurance, you don't have enough insurance to put your house back the way it was. We call that underinsurance. So our focus today is, was your home underinsured? What are your remedies and options? And I've assembled an all-star panel to join me in providing you with news you can use, so that if in fact you are one of those people, one of those 2/3, a very stubborn number after almost every disaster, what can you do about it? So I've got with me, I'm going to tell you a little bit about our organization. Obviously, we always prefer to be with you in person, but with the shelter in place and the pandemic, and also because we made this program available to people all over the state of California, from wildfires from 2017, 18, and 19. Fortunately, we haven't had any in 2020 yet, knock on wood. But we have made this available throughout the state. So this is the best medium to get to you, the virtual medium of a Zoom webinar. So bear with us if we have any technical challenges, but we're here. And you can, if you have questions, you can use the chat box, but we're going to get through the program, and then hopefully we'll have an opportunity for some questions. So what is United Policyholders? You probably already know since you're on here. We're a 501c3 not-for-profit charitable organization. We're a voice and an information resource for consumers of insurance in all 50 states. We have a 29-year track record and subject expertise in insurance and disaster recovery. We're not for profit, not for sale, meaning we are not funded by the insurance industry or any one group, other than we're funded by donations and grants, and we have an amazing volunteer core. And the three panelists that are with me today are all part of that volunteer core. This is how we get our work done. United Policyholders has a small staff, a small team, but a big volunteer core and a big network of experts that respect what we do and support what we do. You can get 24/7 help on the web at our website, and we will visit that during the program briefly to show you some of the things that may help you there. Today's presenters and partners, myself, I'm the executive director of UP and a co-founder. I'm going to be giving you the basic guidance that we offer through our Roadmap to Recovery workshops when we do them in person. What's the best guidance that we can give you on what do you do when your insurance on your home comes up short? And I will walk you through that guidance. We've got a special guest here, Joel Laucher, who is a deputy insurance commissioner with the California Department of Insurance. He will briefly review the complaint process and how the department has helped underinsured wildfire survivors over the many years that this has been a problem. We have another special guest, Erik Feingold, who's got the dual credibility of being a wildfire survivor himself and an attorney. And he will talk a little bit about his neighbor's experience. You know, all of our volunteers like Erik, who've been through a disaster and are paying forward help that they got by becoming a volunteer with our organization. They have a lot of really kind of homegrown, honest wisdom to share. And often somebody like Erik becomes somebody that people will go to. Neighbors will go and ask advice, family members, friends. because they know you went through it, and they're looking for that guidance. And then we also have another special guest, Dennis Neal Jones, who is an attorney who is representing clients right now in suing SoCal Edison. So he's going to be able to walk us through what that option is if you're underinsured, how a lawsuit against a utility, if there have been determined to be at fault, can get you some money to rebuild. So we're going to talk about what has worked or not for previous disaster victims to solve this problem. What can the CDI do to help? What do United Policyholders survey results tell us? And how about filing a lawsuit? These are our funders. We're going to thank them again at the end. Fine print. This workshop is intended to be general guidance and not legal advice. We don't endorse or warrant any of the sponsors listed on our website or the speakers at our workshops. They are here as educators. Just a little bit about me. I have dedicated my entire career to advancing the interests of insurance policyholders, insurance consumers. Since 1984, I'm a published author. I, for a while, was a trial lawyer representing people like you who felt that they had been mistreated by their insurance company and needed a lawyer to sue for them. I co-founded UP in 1991 with a claim adjusting whistleblower. And over the years, I got away from being a practicing lawyer and I'm now a full-time, have been since 2005, a full-time consumer advocate and the primary voice behind UP. I work with regulators throughout the country. I have been beating the drum all over the country for many years that this underinsurance problem has got to be solved. And it's obviously a very tenacious problem. I'm on a committee that advises the Treasury, mostly on disaster, why insurance falls short, etc. Joel is now a special consultant to the CDI. He worked there for 33 years. He has participated in many of our Roadmap to Recovery workshops. We're very grateful to Joel for showing up and caring. He's very familiar with how insurance rates are set and policy forms get approved. He's been the division chief for both consumer services and the market conduct division, which is where they do audits. So hi, Joel.
Hi, Amy.
He's also, I don't know if I'm allowed to say this, but we try to keep things a little bit light. He's a beer expert. So if you have questions about beer, you can save those to the end. If we have time, you can ask Joel. Dennis has been my go-to guy for years on earth movement cases, which can be very hard with insurance, to get an insurance company to pay for earth movement, landslides, but he is deep in the practice of now of representing wildfire survivors in suing utilities, in addition to suing insurers. He is the co-managing partner at a firm that has a long name, and Myers, Witters, Gibson, Jones, and Feingold. He's got 30 years of insurance coverage and civil litigation experience, and has been distinguished as a super lawyer 12 times by Law and Politics, and is quite the expert. Hi, Dennis.
Hi, Amy. Hello, everybody that's watching too.
Yes, and again, now, just like Joel's got the beer specialty, Dennis is a musician, very accomplished musician, and his band. What's the name of your band, Dennis?
Sgt. Pepper.
Sgt. Pepper. Okay, you guys are based in Ventura, correct?
Yes.
Okay, so they're in that part of the state. Joel is up here in Northern Cal with me and Mark Dillman, who is also on the call. He's our staff counsel to help with your questions. And then our last special guest here, Erik, is who I referred to earlier. He's got that dual cred. He's also a partner at the same firm with Dennis. He's got 23 years of trial and litigation experience. He's been named to the Who's Who in Professional Services many times here by the Pacific Coast Business Times. and he has that sad but proud, because he made it through distinction of being a wildfire survivor. So Erik, hi. If you would walk us through your journey home briefly, that would be great.
Sure. Thanks, Amy. That's a nice introduction, and nice to meet you all. Sorry we're meeting under these circumstances, but we're glad to be here to help. So this slideshow is just a little context about who I am and how I got to be doing what I'm doing for people like you. I live in Ventura, California, where the Thomas Fire back in December of 2017 swept through our community. You can go to the next slide. My family's lived in Ventura for over 40 years. I have lots of relatives in town, and this was the first time something like this happened in the city of Ventura. So these next couple slides are what the Thomas, for any of you who've been to Ventura, it's a beachside community, and the town just became really overwhelmed in a very, very short amount of time with the fire. So there's my house. I didn't take that picture. One of my neighbors took that picture later on and shared that with me. But we lived in that house for 10 years. It's where my kids were born, and we raised our family. And yeah, it was really, it's upsetting for me to see that picture now, but that's what it looked like. And then the next day I came back, and that's what I had. That's me wearing my mask. I didn't know those masks would be so in vogue now, but back then that was definitely the de jure uniform in Ventura. But that was my house. That was the remnants of my house. The next slide is a picture of, can you go to the next one? Yeah, this is, and you know, I'll tell you some pluses and minuses of State Farm, but you know, overall, I'm going to give them a good ranking for what they did with my family with this disaster. This is the next day after the fire, and that's a picture of me in my front courtyard. We live up on the hill, and it's a picture of me on the right with the white shirt. And the guy on the left is the State Farm adjuster, and he contacted me that the house was still on fire, and I was talking to State Farm, and I arranged a meeting, and you know, we just started the process. And you know, one of the things I'll talk about in my presentation later is the importance of record keeping and taking notes. And you'll note that, I mean, I came from this with an insurance background, so in my lap in that picture there's a notepad, because I was writing down everything that guy was saying, and I'll talk about that. I'll allude to that a little bit later. And then as we go through the process, then my wife and kids came. Once it was cleared out, my wife and kids came and kind of sifted through stuff. And you know, for those of you who have been through this, you know that there's not a whole lot left in a situation like that. Basically, porcelain. That was all we were able to find. But we got the process started really quickly. I was able to get a contractor involved, and I have some points about that, and hopefully some experiences that'll help you all with how to sit through that process. And you can go to the next slide, Amy. So it didn't take long. I mean, within you know, weeks, the city of Ventura had a program that was probably similar to many of your communities, where they expedited the building permit process. And we had approved plans within, you know, a few weeks of the house burning down. They got the lot cleared. And then, you know, by, you know, less than a year, 8 months after the fire, you know, we had already graded, we had already put down the foundation. And if you keep going through, Amy. And then, you know, within a couple months of that, you know, the framing was up. And then if you keep going a little bit further, one more slide. And then by, you know, within a year, less than a year, we had a house. It wasn't ready for occupancy at that point. It was still going to be another 8 or 9 months, but you know, our house was framed, and our decks were in, and I'm proud to say that, you know, my neighborhood was pretty ravaged, the section of my neighborhood, and we were the first ones to be framed, and we were the first ones to be completed. And you know, going into this process, I always thought that, you know, the good news is that we're really ahead of the curve here, and we're getting through this. The bad news is that we're going to be moved back into our neighborhood, and the whole place is going to be under construction for years. And unfortunately, we're now 2.5 years past the fire, and my whole neighborhood is under construction. And you know, we're having to live with the hammers and the nails and the trucks and the air compressors and the tile saws all around us. But you know, it's good to be home, and we're really glad that the process moved along as quickly as it did, especially since our rent was running out. And this is it. We were this is from the same time period. This is a perspective drone shot. You can see around us, on the left of us, beneath us, all above us, everybody's house was burned down. Basically, everybody to our west was saved, but then everyone to our east was burned down. And for the most part, my neighborhood still looks like that. And I'm currently in my office, which is on the first floor of the house you see there in the foreground. And then next shot, Amy. Yeah, and then September of last year, we're done. We moved in, we got our occupancy, and that's where we are now. And and again, our neighborhood still looks like that. I mean, you can still, most of the lots above me, they're still under construction. The lot next door to me, they still haven't started on that one. But it was important for me to get this process moving very quickly. I really kept the pedal to the metal with the insurance company. I got the benefits I needed to get this house built, and I did it mainly for my kids' sake, because I needed to have them normalized and stabilized, and mission accomplished. And I did it, and I think that with some of my information, hopefully you can too.
Well, I really appreciate that, Erik. And I know for those of you who are dialed in and saying, oh my gosh, how did that guy do it so quickly? And what about me? I'm still sitting here worrying about running out of my ALE, and I feel like I'm still, in some ways behind. And I am here to tell you that there's a big range. And I think Erik, Erik's a good example of, like, you're going to get through it. That's for sure. But I'd say the number of people that are able to get back in a rebuild house before year 2 or even year 3 is still far lower than the number of people that are, like Erik said, still doing construction right now. So keep your heads up and keep heart, and we'll get into one of the reasons why I think that it does take people so long when they're not properly insured, is that it creates a kind of limbo, not knowing knowing that you don't have enough insurance that's going to cover your construction project to replace the home you had, puts a lot of people in limbo, and it makes it very hard. So for those of you who are looking for some ideas, that's what we're here for. We've already gone over, obviously, the fact that it's a really common problem. These are 2 of the more recent surveys that we have done. One that we did for the 2017 North Bay fires, one that we did for the 2018 Camp Fire. Both of those surveys were consistent. About 2/3 of the people reported that they didn't have enough insurance on their structure. Now, we realize that there's a big range. Some people are underinsured a little, some people are underinsured a lot. And it's obviously much harder to figure out how to move forward if you're underinsured by a lot. This is a very old, stubborn problem. Joel, you were around after the Oakland fire. So you know that after that fire, a lot of people were upset because their neighbors had a policy that really barely exists anymore, a guaranteed replacement policy, but then they didn't. So Joel, what would you say that you first observed back then about how people were going about tackling the problem of being underinsured?
Yeah, Amy, as you pointed out, there was that guaranteed replacement cost option that a few people had purchased from their insurer, but that many insurers offered, but simply hadn't really made well known to the insureds they already had on the books. And I think what happened in Oakland in particular, and you can imagine Oakland, Berkeley, a lot of community organization, and ended up with a lot of people fighting as a group to, obtain, to make the pitch that you, the insurer, offers this guaranteed replacement cost coverage, and you have not offered it to me, your longtime customer. You make that known to new customers. And, by way of that community action and a lot of the litigation, I think a lot of insurers caved in there and provided guaranteed replacement cost limits, which was basically whatever it cost to rebuild the home as it was. They gave you that amount despite the limit on the policy. And Amy, as you know, that guaranteed replacement cost policy quickly disappeared from the marketplace almost entirely as an option.
Yeah. So so far, I know all we've given you is bad news, and there is some good news. So really, it is that actually, if you listen closely to what Joel was saying, he said community organizing, and he was talking about pressure, and that people brought to bear as a group, and that is hard for some of you because you're spread out all over the state. So let's get into some of the other. We've done some legislative approaches, which is why now you have 24 or 36 months of ALE. So because a lot of people were underinsured for that. You also have now, but it may not have helped you, some of you on this call, the requirement that insurance policies, home insurance policies in California contain some kind of extended replacement cost feature, so that to give you a little bit more coverage. And on that one, all I can tell you is to, hopefully you have looked very closely at your policy, your deck page. Don't rely solely on what your insurance company adjuster has told you, because you want to really make sure that you may have an ERC extended replacement pocket. And if you don't, that would be something to check in with the Department of Insurance Consumer Services Bureau. And I'm going to go back for 1 minute to Joel's slide. Oh, actually, no, we're coming to Joel's slide that has the phone number for the CDI. You can file a complaint and make sure that that your adjuster is giving you credit for every dollar of available coverage in your policy. There is a regulation that's on the books now that wasn't on the books many years ago, that requires your insurer to give you a rebuild estimate, but it's relatively new requirement. So some of you may have not gotten the benefit of that. There were regulations that the department spent many years developing, and I was part of that effort. Insurance companies sued to block them. Those were regulations, again, trying to shift the duty to set limits accurately where it belongs, which is on insurance companies. They're paying claims all over the country every day, hopefully. So they know what it costs to put a house back. Most homeowners have no idea what it would cost to put their house back. So they have no idea how much to insure it for. They know what they paid for it. They know what they could sell it for, or a ballpark, but we're not builders, we're not contractors. But the problem is that the law doesn't reflect reality, and we're going to talk about that in a minute. So some of the solutions haven't really helped in a way, because a lot of the solutions have been disclosure. So now the insurers, not only did they get rid of guaranteed replacement policies, but they now have a disclosure form, and they can say, look, we told them that they had this limited coverage. So you do need to pay attention and save the communications that you get going forward. But here's a little bit of good news. This is a lawsuit that is pending on behalf of some of the 2017 wildfire survivors. It's pending, and apparently I spoke to the attorney before this seminar, Greg Bentley. This is a group of underinsured homeowners that are suing CSAA, and he tells me that it's going very well. They are pushing for they're going on a lot of different theories that the software that the insurers use to set your coverage A limits is flawed, that they knew that so many people are coming up short, and they continue to use the same methodology. So this lawsuit is pending, even though obviously it's 3 years after people lost their homes, and that's how long it takes. And I know to really, most of the time, if a lawsuit doesn't settle right away, which many of them do, they generally won't settle until the eve of trial. Right, Dennis?
Right.
Okay. So don't just because you're sitting here listening to this, and maybe you haven't joined a lawsuit, doesn't mean it's too late. And I'm not pro-lawsuit or anti-lawsuit. I'm just pro-reality and pro-solutions. So that is one avenue, and Dennis is gonna give us the really good news about for those of you who are plaintiffs in the lawsuit against SoCal, at least that's a good news in the sense that that suit is moving along and there are settlement discussions underway, just as there's been with the PG&E suits for the camp and the 2017 wildfire survivors. Okay, so we won a round in the California Supreme Court in 2017 in a case where the insurers had sued the department to say, you can't make us change our ways in setting the policy limits. And the court said, yes, they can. Yes, the department can. So that is still kind of really, believe it or not, a 2017 California Supreme Court decision will still have the potential to help you, even though it's hard to understand that, but it's true. So an overview, the law doesn't reflect reality, but the law, it may be changing, and it only changes when people like you push to change it. The reality is that most of you, probably all of you, relied on your agents or your insurer to set your limits. But the law, that's reality, right? We don't know, I was talking like, we don't know what it would cost to put our houses back, but we know that if we're talking to an insurance agent or broker or an insurance company, we just assume, reasonably rely on them to know what they're talking about and to set our limits right. But the problem is that doesn't always happen, various reasons. They know that you want to pay the lowest price, and so often they will try to give you what they think you need. But most of the time, they're just using the same flawed software that insurers have been using that lowballs that coverage A and gets you in a pickle. The problem is the law. The law says that your agent and insurer only have a general duty to insure your property, not a special duty to insure it adequately, unless that agent or insurer undertook that special duty, assumed it, and you have proof that they did that. So like I said, pressure is building to change the law. What are the options if you don't want to go into a lawsuit? Self-help. Do you have evidence that your insurer, agent, or broker assured you that your limits were adequate? And when I say not he said, she said, that's to say that everybody says that, and it's true probably most of the time, you know, but if you don't have proof, if you don't have evidence, generally you're going to have a tough time in court. But as you saw, some people who have joined lawsuits against specific insurers are prevailing. But if you don't want to go that route, self-help can sometimes work. And that means if you have some evidence, it's not just your word against the agent. You know, you say, Mr. So-and-so promised me that my policy was adequate, but that's all you have. You have no emails, you have no written records, no notes, nothing that you can prove that conversation happened. That's he said, she said, and courts generally do not find that enough. So if you're going the self-help route, and it definitely works for some people, generally you're going to be getting what's called a retroactive reformation of the policy limits, and you may have to pay the difference in the premiums for what your limits should have been. Erik, you and I had a good chat about this phenomenon, and I said to you, you know, it's hard to get information about people succeeding in this because most of the time, if they do succeed in behind the scenes negotiations with their insurer to get their retroactive reformation, why is it so hard, Erik? Share with us why it's hard to know who's been successful at that and what the outcome was.
Well, Dennis and I had the same experience after the Thomas fire here in Ventura. I mean, there's not a lot of other insurance lawyers in town. So Dennis and I got a lot of calls from people who were underinsured and were having problems, you know, especially when they got their contractor estimates to rebuild their homes. And one of the angles that we look at, and that, you know, I've pursued successfully on a couple of occasions, is to establish that somebody dropped the ball. and that either the agent didn't relay the information to the insurance company, or that the insurance company, once they received the information, didn't write the policy correctly to place the insurance in adequate limits in order to rebuild the property. But except for those narrow circumstances, when people call us and they would say, well, I told the agent this, or I assumed the agent would do that, it's just not enough. And more often than not, sadly, what I would see in my practice was people saying, well, I bought my house back in the 80s. I got homeowners insurance because I needed it for my mortgage. And then the policy just kept on going from one agent to another. The agent would transfer it to another agent. The agency would close and go to another agent. And nobody ever called me, and no one ever checked up on me, and no one ever made sure that, you know, my needs had changed. And then their house burns down. It turns out they have $150 a square foot to rebuild their house, which probably would have been great in 1988, but not today. And the challenge with that was always, well, do you have an email with your agent? Well, I told the agent so many times, and you know, unless you have something, as you said, Amy, above, you know, a he said, she said scenario, unless there's a paper trail, it usually led to disappointment. I relayed to you a circumstance that I had involving a client where we were able to prove that the insurance company dropped the ball, that there was I think it was a 3,500 square foot house that needed to insure. They told the agent it was 3,500 square feet. The insurance company writes a policy for 3,000 square feet, and the policy comes in the mail. The policyholder never checked it. They stuck it in the back of their drawer. The house burns down, and then they get a copy of the policy. They say, well, somebody made a mistake, and that insurance company agreed to reform the policy. I think they charged them a nominal premium, but then they paid for the 3,500 square foot house. But we had a paper trail in that case, and I was able to take that to the insurance company and say, look, you guys need to reform the policy. There's a mistake on your end. But absent that, it's tough. It's a really tough road.
Right. Plus, those who do succeed are generally asked to sign confidentiality agreements, so they're not allowed to share the details. So, for example, Karen Remus, who is one of our volunteers who lost her home in the Cedar Fire in 2003, so she negotiated a confidential above limit settlement with her insurer. But she's not allowed to say, you know, what the dollar amount is. She can say that it happened, but she can't say, you know, the details. Joel, could you talk a little bit about the Department of Insurance complaint, the process where you can file a complaint? And I know that you guys have succeeded in getting some underinsured situations resolved. Can you just give a brief explanation of that?
Yeah, and first I should say thank you, Amy, for inviting us, and the department really appreciates all the work you do for insurance consumers. So thanks for having me join you here today. I think you'll see a slide later on that shows our web address and 800 phone number. So one of the things about the department that people appreciate, I hope, is that we are free to the consumer. So it's one of those things that I guess our president might say, why not try it? But this is actually a positive thing. You can come to the department, file your complaint. A lot of the things that Amy and Dennis and Erik have already mentioned are the things that we look for as well in reviewing that file. Basically, did the insurer insure based on your representations about the size of the property or the age of the property? So does that estimate of replacement cost reflect those things? We look also, as mentioned, for actual documentation of agent or company representations about your coverage and you know whether you're all good or not, and some general words that they might put out there that imply that your limits are adequate. We look at, on the claim side, we would certainly look at the scope of loss to make sure the insurer has captured an adequate picture of the loss. We would look to see where you offered the optional coverages that insurer offers or updated coverages. You know, there are little glitchy things that happen along the way, like some consumers ask for an increase to their limit, and the insurer will do that, but then not apply the inflation factor that it applies to its whole book of business every year until your home hits their estimate again. And you never told them to turn off the inflation factor component because you just wanted to bring it up to whatever limits at the time you thought were adequate. And yes, you would want inflation factors to apply. So we try to find, you know, little discrepancies between, you know, what the insurer has done and its standard procedures. I will note that I think for 2017, we had about 190 underinsurance complaints. Most of those are closed. We did get 13.5 million or so in recoveries on those files. You know, sometimes you get a big recovery and some are very small, but in range, you know, there was quite a few less underinsurance complaints from 2018, only 69. Half of those are closed, and only about 600,000 in recoveries. So it's really about trying to find something, you know, maybe wrong with the estimated replacement cost. Also, I'll mention that one of the components of the estimate of replacement cost is that it has to be, the costs have to be specific to your geographic location. And some insurers don't do a very good job of really fitting costs to the actual geographic location. The estimates that the consumer receives typically don't reflect or make apparent what was used for the geographic location. And we know that some of the people up in the more remote hills, the cost estimates may reflect county-wide, right? They may incorporate rebuilding in Chico, for example, which may be a lot less expensive than a rebuild up in Paradise or Magalia. So, you know, that's what we're looking for, those same little fissures of the insurer's deeds and actions and your coverage to see if there's a foothold for finding an obligation by the insurer to pay some more money.
Yeah. Okay, so I'm just going to go through a couple of steps for the self-help, meaning, you know, where you're trying to do this on your own by using leverage or evidence. So check your policy for obvious errors. You heard Erik mention that. You heard Joel mention that. That is one of the helpful ways to get your limits adjusted, is if the insurer made some sort of mistake in your square footage, that sort of thing. Or even situations where the address is wrong or what have you. In order to quantify how underinsured you are, you need to get a rebuild estimate of what it would cost to put back the house that you had, what your home should have been insured for. You need to review the history of how and when your limits were set. Again, we've been going over these points. Did you remodel, refinance, change insurers or agents? Those are things that might generate evidence that would help you show that you were reasonable in relying on the insurer or the agent to set your limit accurately, and it's not your fault that you aren't. Did something trigger you to contact the insurer? Do you have anything in writing? If possible, seek out and compare notes with other property owners who are or were underinsured by your same agent or insurance company. So that lawsuit that I showed you earlier on behalf of the CSAA customers, that came out of a group that they formed that you know, people met through our organization. They formed a little communication group, a phone tree, email group of everybody who was insured with CSAA that lost their homes in that the 2017 fire. And they worked together. They hired a lawyer together. They probably got a better rate on the lawyer fee because they were a group. And so that's an option if it's possible. Step 5, make a clear written demand that your insurance company and or agent honor the promises that were made. I mean, this is the hard part. You know, equity, fairness is on your side, that it's not your fault. And, you know, if you refuse a recommendation to increase your limits, then there's not a remedy for you here. But if you took their recommendations that your agent or insurer made, and you're still underinsured, then you can certainly make these arguments. Let them know that you're underinsured through no fault of your own. Tell them the exact amounts by which you're underinsured. Provide them with the documentation that we suggested that you get. Best practices: keep the communication professional, be concise and to the point. Don't write 10-page letters. They're not going to get read, and it's just not helpful. State your case in bullet points and bold. Avoid long paragraphs. Use good grammar and punctuation. Point out unreasonable requests that they've made. Common sense is going to be on your side. And this is the really hard one. Avoid venting your frustrations and emotions to your adjuster. Very often they simply don't have the authority to do what you're asking them to do. That's something that would have to happen above their head. And use your personal leverage. Where does that come from? Was your home damaged in a federally declared disaster? How long have you lived in the home? Are you a retired senior citizen, a busy professional? And I want to pause here for a second. We've been talking about, we've been talking about your home being underinsured. We know that many of you are also underinsured for your additional living expense or your loss of use. But the same advice goes no matter whether you're underinsured on your house or your stuff, your landscaping or your temporary rent, loss of use, ALE, they're all the same thing, different labels. If you make the same steps, this is what I should have been insured for. It's not my fault. And this is why I believe it's your fault and you need to make good on it. But you say that as professionally as you can. And then, Mark, is there anything you wanted to add on that?
No, I just wanted to throw that one out there. I know that was an important distinction to be made during the presentation. And again, I see questions coming in. We appreciate it. And we'll hold those for the end, but just wanted to get those as a matter of clarity out of the way. Okay,
thank you. And I see it says here on the bottom, if your insurer responds by sending you a written questionnaire with questions that get at how your limits were set, see step 6. And this is where we say, if you get a questionnaire, and State Farm does this, they send like a 3-page questionnaire asking you a whole bunch of questions, or they say, well, we want to examine you under oath. I'd like either Dennis or Erik to address this step 6. Why do we recommend that people consult with an attorney before they complete one of those questionnaires or give a recorded statement?
I'll let Dennis take this one. You're on.
Dennis, you might need to unmute.
Right. I'm not sure I followed a recorded statement about what?
No, the question is, if you are an underinsured policyholder and you have made your request and you have said to the insurance company, I'm asking you to retroactively increase my limits to where they should have been if you had properly insured my home, and the insurance company responds by giving you a questionnaire to fill out or asking you to give a recorded statement or an examination under oath as to how your limits were set, why do we recommend that people not just go in and do that on their own, that they consult with an experienced policyholder attorney before they complete the questionnaire or agree to give the statement?
Right. I haven't actually represented anyone in connection with that attempt, but I think in general it's a bad idea because the insurance company isn't going to ask you for the recorded statement in order to help you. They're circling the wagons and thinking that they may be sued, and so they're going to try to get whatever information they think that they can get that will help them in the event that you do sue them. And without having an attorney present, you don't really you have no way of knowing what are the acceptable parameters, what are acceptable questions, what are not acceptable questions. And, you know, they could possibly invade attorney-client privilege or other privileges that may apply that the ordinary consumer would not know, that they don't have to answer those types of questions. That's just my thoughts off the top of my head.
Yeah, well, that's exactly, that's consistent with the guidance that we put out, that when you are trying to get a retroactive reformation of your policy limits on your own, you basically are having to make legal arguments, even though you're not a lawyer. You're saying that they undertook the duty and you reasonably relied and that sort of thing. You don't have to use those words, but the only generally, you know, if so many people are coming back to their insurers and trying to get their limits adjusted, that the insurers have developed ways to try to screen who's got a good underinsurance case, who might have a shot at winning if they went to court versus who doesn't. And again, the department is a free opportunity there too. So before we get to the questions and the part about suing utility companies as a way of recovering your gap, Erik, was there something you wanted to add about strategies you have helped your neighbors use, your underinsured neighbors use? Is there anything you wanted to add to what you already said?
You know, the obvious things are what you've mentioned already, Amy, having to do with examining the policy really closely, looking at avenues for a claim against the agent or the insurance company for placing the wrong type of coverage. Barring that, the neighbors that I've seen successfully rebuild who are underinsured, they would try to group together and try to get a contractor. I've found a lot of contractors are willing to lower their price per square foot if they know that they're going to get more than one person in the neighborhood, especially if the contractor is going to be local and they can just kind of establish a base camp and work on the entire neighborhood. I've seen people drastically reduce their construction costs that way. And then there's also the prospect of obtaining construction loans, but you know, that's all going to be dependent, or I've seen it be dependent on how much equity is in the house and a number of other factors. But you know, barring that, sadly, the usual circumstances I've seen are people just having to sell their lots and cashing out on their insurance proceeds, which is a whole other topic I could address. But there's strategies involved with that as well.
Okay. Well, let's get to Dennis's presentation, and then we will take questions. And I think sounds like we have a number of them. So, okay, Dennis, talk to us about suing a utility company to recover your underinsurance gap.
Okay, why don't you go to the next slide? The challenges that I have seen in representing fire victims for going back to 2003, the Simi Valley wildfires were the first fires that I got involved representing policyholders in disputes with their insurance company. And the biggest one is inadequate limits, which applies, of course, only to total loss cases. But there are also lots of disputes going on about soot and ash and heat damage, because for a long time, insurance companies treated those as, well, it's not really damage. If smoke gets inside of your house, that's not damage. And so they would pay, but we'll pay for 2 Molly maids to come in for a couple of days to clean your house. That was back in 2004, 2008, the San Diego wildfires. The insurance companies were still taking that position. When I knew, because I was dealing with a lot of hygienists in mold cases for about 10 years, talking to the hygienist said, no, soot and ash can get into your insulation. The insulation has to be replaced. It can get into your ductwork. The ductwork has to be cleaned or replaced. That has to be done by a professional restoration company, not a couple of Molly maids. And so I've battled with insurance companies going back to 2003 over that issue and have handled several thousand soot and ash claims. But the main problem with regard to my topic is, we can go to the next slide, is that almost everybody that had a total loss in the wildfires that have occurred the last 3 years was underinsured. We have about 1,300 Thomas Fire clients in our group, which is California Fire Lawyers, I'm only aware of 2 who had full guaranteed replacement cost coverage. And those people had it because they've had the same policies since before the Oakland fire in 1994. It was after the Oakland fire that insurance companies stopped giving guaranteed replacement cost coverage. So now when you see that you have replacement cost coverage in your policy, it's not really guaranteed replacement cost. It's simply an extension of coverage. They will say, we will provide another 10% or up to 50% of your limit if necessary to cover the replacement cost of your home. Or it may be an extension of coverage that provides another 100,000 or 200, a set limit of coverage. But the bottom line is that almost all of the total loss cases are underinsured. And I'll tell you why when you go to the next slide. Because when the policies were underwritten over the past 10 years or so, the insurance companies were figuring that it would cost about $225 a square foot to rebuild a house. And that may have been true at one time, but it's not true anymore. And Erik can tell you what he paid per square foot, but the information I'm getting is that the average square foot is closer to $400 a square foot to rebuild a house now than to $225. And the insurance companies will say, well, you know, if we give you a higher limit, we increase the premium. So we have every incentive to try to fully insure a house. But the problem is that the software that they're using is flawed, as Amy pointed out a few minutes ago. And so oftentimes on the first page of your policy, the declarations page, it will show you how it calculated the limit. And it may say, you know, $216 a square foot. Now they're not allowed to do that as a result of some new legislation that I think Amy referred to. They have to separately quantify the cost of materials, the cost of labor, that type of thing, permits. But when your policies that are involved in the fire were written, they were using per square foot, and costs of construction have gone up as a result of the fires. Contractors are charging more, and materials are costing more. So the question comes, who's responsible for the underinsurance? You can go to the next slide. We'll go through these quickly because Amy's already talked about them. The law in California is that generally an insurance company is not obligated to determine that you have sufficient limits to rebuild your house. And similarly, going to the next slide, insurance brokers are also not responsible to make sure that you have a proper limit. What normally happens is people use independent brokers to buy their homeowners insurance, and the broker will simply give the address to the insurance company. The insurance company puts it into their computer. They have their software, their flawed software that determines per square foot, and they make an offer to the broker. We'll provide a $600,000 coverage A limit, and we'll charge $1,900 for this policy. And that's an offer that then is communicated to the policyholder. They can accept it. Usually they just accept it without question, because policyholders generally don't know what it will cost to rebuild their house. And so they just assume that the insurance company is going to fully insure them, and they accept the offer. If they want to ask for a higher premium, they can, and many insurance companies will give you a higher limit if you ask for it, but most people don't. And so the problem is then the brokers also are generally not responsible to determine what the policy limit should be, unless they assume the role of a risk manager. And a risk manager is someone who does determine what your limits should be. But most independent brokers will not assume that role, precisely because they don't want to assume liability if it turns out that what's offered by the insurance company is inadequate. So we can go to the next slide, but the bottom line is that, well, there are some exceptions. If a broker misrepresents the scope of coverage, if you ask for a specific limit and they fail to obtain it, or if they assume a greater duty of a risk manager. But the bottom line, going to the next slide, is that in most cases that we are looking at, the policyholder is responsible for inadequate limits. Now, I'm talking about historically. As Amy mentioned, there are some lawsuits pending in which the policyholders are claiming that insurance companies have systematically underinsured property and that they bear some responsibility for that. So it's possible that they may change the law, but, and I hope that they can, but I'm not particularly confident that they are going to be able to do that. And of course, if you ask the insurance company to reform your limit and they agree, then that's great. But I'm dealing with people whose insurance companies are not willing to reform their limits, whose insurance brokers are not liable in most cases. And so the question becomes, how do we obtain the underinsured losses? How do we obtain our clients' underinsured losses? And in my opinion, the best way of doing that is to sue the utility companies to join one of the lawsuits, because utility companies are liable for all damage caused by fires that start on their equipment. And this is a form of strict liability. We can go to the next slide. It's called inverse condemnation. It's strict liability. And there are only two elements to a strict liability claim. You can go to the next slide. Number one, is it a public project? And a utility is considered a quasi-public entity. So a utility company is a public project, and power lines are a public project. So did the damage start on the public project, and did it cause damage? There's no requirement that we prove that the fire was caused by negligence. Strict liability is easier to prove than negligence, because you don't have to prove that they did anything wrong. We only have to prove that the fire started on their equipment, not as the result of arson or lightning or something like that, that there was some sort of a failure that caused the fire. So we can go to the next slide. In these cases against the public utilities, there's a wide range of damages that are recoverable. I just realized a few minutes ago that I forgot to put bodily injury and wrongful death damages on this list. And I think the reason is that my firm is not representing any wrongful death plaintiffs or bodily injury plaintiffs in the litigation. We're only dealing with property damage for businesses, for individuals, for growers, and so forth. But generally, you can recover all of your uninsured or underinsured losses. And the reason I say that is that to the extent your insurance companies pay you on your claim, the insurance companies now own that claim, and that's what's called subrogation. And all of the insurance companies are in the litigation on a separate track called the subrogation track, in which they are trying to get back the money that they paid their policyholders. And that's the way insurance coverage works. To the extent you are insured and your insurance company does pay you, you no longer have the right to recover for that amount of money. That is transferred to your insurance company. But to the extent that you are underinsured or uninsured for some losses, you still own those claims. So that is the purpose of all of this litigation that's going on against PG&E and against Southern California Edison statewide. The whole goal of that litigation is to recover uninsured and underinsured losses suffered by our clients so that we can help make our clients whole. We can go to the next slide. This type of litigation carries very little risk to the plaintiffs because the attorneys are handling them on a full contingency. They're advancing all costs and fees. And in most cases, when lawyers handle a case on a contingency, if they lose the case, the clients are still responsible for the fees. But that's not true in our fee agreements, and I believe it's also not true in the fee agreements of the other lawyers that are handling these cases. The lawyers are assuming the risk that they may advance, hundreds of thousands of dollars in expert fees, and they are advancing hundreds of thousands, if not millions of dollars in expert fees. And if they should lose the case, the clients will never have to pay any of those fees. So there's not a lot of risk to participation, but there are time limitations, which will take me to my next slide. And the statutes and limitations on these fire claims are 2 years from the date of the fire for bodily injury and wrongful death cases, and 3 years from the date of the fire for property damage claims. So, for example, the Thomas fire, I think, was started on December 5th, 2017. We're now getting the 2-year statute of limitations has now passed. And so there can be no new claims for bodily injury or property damage, with the exception of minors, because the statute of limitations does not apply to minors, but children, people that are under the age of 18. But there is still time for people to join the Thomas Fire litigation if they have property damage. And then, the fires that occurred in 2018, the Camp Fire, the Woolsey Fire, there may be others, but the statutes have not expired yet as to those. So the bottom line, coming to the final slide, is that I think that joining these mass tort cases against the utilities that started the fire is the best way to recover underinsured and uninsured losses.
So Dennis, thank you. I have 2 questions. So you said it's not too late for the Woolsey and Hill, and then of course the 2019s, and then the Northern Cal people as well, to join one of these suits. But with PG&E, do you know? I know that United Policyholders did a whole separate webinar about the PG&E settlement, but it was a while ago, and I know recently there was some sort of announcement. It's too late to join to join a suit against PG&E now, isn't it?
Well, I knew you were going to ask me that, and I don't know the answer because we are only involved in the Thomas and Woolsey fire cases. We're not involved in the norm. But yeah, since PG&E is in bankruptcy, as soon as I said that, I realized I probably should have qualified.
That's okay. That's okay. I think people are pretty, it's just been in the news like crazy, so I think people are pretty aware. But my other question is, and for those of you who are listening, if you want to see the recording of the webinar that we did just about the PG&E suit, you can find the link to it at our website. But I think that, so the question is, with this pandemic, I know a lot of the courts have been closed. So is there progress being made in the SoCal Edison suit, or is it stalled?
There is progress being made. Of course, we can't file anything and there are no hearings going on, but the judge that has all of the cases, both judges that have the 2 cases, have been communicating through the system that's in place for filing and for communicating with counsel about the case. All of the public entity claims settled in the Woolsey and Thomas fire at the end of last year, and the subrogation claims are now in mediation. So the cases have started to settle. We have a mediation scheduled in 2 weeks for the first 10 individual claims in the Thomas fire. So we're going to have a mediation on, I want to say June 11th, of the first 10 individual claims, and we'll get a sense of how anxious is Edison to start settling those claims. But they are moving forward towards settlement. We're continuing to work up the cases for trial in case they don't settle. But yes, the pandemic has put the litigation on hold somewhat, and the bellwether trials have been continued now twice. In other words,
bellwether trial.
Yeah, the bellwether trials are trials that are selected, individual cases that are selected to be tried. The idea is if you pick 10 cases, you get jury verdicts in those 10 cases, that's going to give you an idea of what the cases are going to come in at, the other cases, and they can then be used as a roadmap, as a guideline to settle all the other cases.
Okay, a fantastic amount of information, and if you're willing, I'd like to have you guys stay on. We hit the hour, but we didn't have a set end time up until 5:30. So if you were willing, I'd like us to take some of the questions, as I think certainly like to hear more from you, Erik and Joel, and I know actually Joel. Before we get into the questions, what is the best way for a person to find out, go on your website, insurance.ca.gov, what kind of bulletins that your office and the commissioner have issued that speak to the pandemic as in terms of people who are wildfire survivors and are trying to keep on keeping on. I know that you've issued quite a number of bulletins. Do you want to, can you just tell us where people can find those on your website?
Yeah, some of those are actually on the front page, I think, right now. We have a banner across in your selections. One of them is news, and you would choose our press releases. Those will connect you. You know, the department did issue a bulletin asking insurers to refund some dollars due to lower exposures, basically fewer miles driven, lower payrolls, less receipts, you know, for mileage for autos, receipts and payrolls for business coverages. And we've done a follow-up with the industry because this issue has prolonged. So you see there's a news banner there. You see there's an information for small businesses right on the front page.
Right, okay, so we've got bulletins. Is that, am I doing this right?
Yeah, and so
Okay.
you can go through the press releases to connect to some of these, or you can go to consumer bulletins.
Okay, so here we
And
go.
You look at the 2020 press releases that are there, and you'll find ones that are about, well, anything that we've been up to.
Okay.
There you're on to the ones about
The auto insurance refunds, etc. Okay, so I just wanted to show our viewers where you would go. So that's very practical.
And just to mention that consumer button that you had up also
oh, sorry,
is where you would go to file a complaint. Let's
go back there. Hold on. Here we go. Consumers, that's where you, okay, that's where you go. And you go to homeowner residential. Yeah, you can see file a complaint there. You can go to the home. And one thing I'd like to mention that actually, again, beyond the scope of this talk, a lot of people getting non-renewed right now, or, you know, having their coverages cease. There is a home insurance finder there to help people look, along with the top 10 tips for finding coverage. It's very difficult for a lot of people in some of these wildland areas to find insurance coverage right now. Yes. So there's some information on our website for that as well. Okay, great. So, and then before we bounce to questions, I want to give, this is one of my favorite things about doing one of our webinars by Zoom, is I can actually help people find things on the UP website as well. So not just the DOI, but our website. So uphelp.org, you probably, if you're watching this, you know that website. But just to review here on our disaster recovery help tab under resources, we have a library. If you happen to be a small business owner, we have a library for you about your coronavirus claims. We've got a campfire library, North Bay 2017. We've got 2019 SoCal, Woolsey, and all those libraries are free, available to you 24/7. If you use our search box and you type in underinsurance, you will, some of the guidance that I went through earlier with you on those steps for trying to take a run at getting your insurer to retroactively adjust your limits, either confidentially, just through negotiations and discussions. You'll find that guidance here, and you'll find post-loss claim tips, some of the lawsuits that people have filed. This one is a suit that's still pending against USAA for underinsuring people. So again, there's lots of information on our website for do-it-yourself options, self-help. And also there is a find help directory where you can find the law firms that support our organization. Here's California. You can filter it if you want an attorney, or if you're looking for somebody a public adjuster or a tax expert, you can get that sort of information here. And I know, Erik, there was a point you wanted to make that some of the folks that that are struggling with underinsurance may be having an extra difficult time because they made a decision early on in their claim. Is that something, do you want to just jump in on that?
Yeah, I do. There's actually a few points I wanted to make. The first having to do with the website that you were just talking about. One thing that, and thank you for mentioning that. I think it's a tremendous resource, and I personally use that in my own claim as part of my own presentation and my negotiations with my insurance company. It is a tremendous resource because there's templates there. And one thing that I don't think you showed on your presentation, Amy,
Right.
is that
the sample.
you don't need to reinvent the wheel. You don't need to sit there and say, well, I didn't go to law school, and how am I supposed to be able to communicate with the insurance company about these things? I mean, not to discredit the services that lawyers provide, but if you could think of a situation you're having with your insurance company, look at the templates. I mean, it is amazing what they've compiled. There's all these form letters with various complaints about ways, you're showing it right now, a letter asking for all these various remedies. And I found that tremendously helpful because I would sit down and I would say, well, I need to extend my living expenses, and oh my gosh, how am I going to do this, and what's the approach I should take? And as opposed to representing it or creating it from whole cloth, I just went to one of the templates there. So use that, and just know that's there, and you can just copy and paste this stuff into letters. And the letters are actually, they're really good, and I'm sure they're as a result of trial and error about which things get the insurance company's attention versus which don't. The other point I wanted to make was, and I alluded to this earlier in my presentation, the first day after the loss, when I'm sitting there with the insurance adjuster who came out, I was taking notes. I still have all my notes, and everything they would say, I would write it down. And everyone I dealt with, I would get their personal email address, because I shifted around through many adjusters. They get their personal email address, and I was exchanging text messages with all these people because, and I saw one of the questions, and I know we'll get to the questions, but one of the questions was, well, the first adjuster said it was $350 a square foot to rebuild, but then the insurance company later said it was going to cost less. What do I do about that? And I don't know what sort of paper trail the person who posed that question has, but when stuff like that would happen with me, the first adjuster says, well, you should be okay, and I think it's going to cost about somewhere between $400 and $450 a square foot. I'd whip out my phone and I'd say, thank you for confirming. It's going to cost between $400 and $450 a square foot. And this is the day after the fire. I had no idea. I didn't know if it was going to cost $450. I've never built a house before, but I'm glad I had that, because later on when they were saying, well, we should be able to squeeze this in under 360, it's like, nope, you can't do that. And your people acknowledged it way back when. And here's the text message that I sent confirming it. And there's various legal mechanisms for basically getting people to admit things if they just adopt it. If you send somebody something and they don't respond to it, then they basically adopted your statement. And that was an argument that I was able to use a few times in the course of my claim. And then addressing the issue that you brought up, Amy, about making decisions. I know that many of these losses were several months ago, but I received advice too late for me to really appreciate it. But the advice I got was, be careful about decisions you make right after the loss, because you're upset, you're traumatized, you're still in shock, and you're having to make all these big decisions about accepting insurance settlements and signing contracts with contractors for sometimes over $1 million, and or signing up with a public adjuster to adjust your claim. And you're having to make all these really important decisions all in a vacuum at a time when you're really upset. So to the extent you can, sleep on this kind of stuff, and before you rattle off some letter to the insurance company, send it to yourself and look at it in the morning and think about the things you're saying. And some of the things that Amy brought up in her presentation was, don't get emotional with these people and try to keep it businesslike. And I mean, adjusters are people who go to work every day, and they're I'm sure they don't go with the intention of of evil wrongdoing towards customers. But these people get horribly abused, and I found that the best way for me to get my point across with my own adjusters, and this is the advice I give my clients, is treat them like professionals and be above board, and think about every letter that you write as someday being exhibited on the side of a courtroom or in a courthouse. Because if you can later prove a claim, and all of a sudden you're writing these inflammatory text messages or letters to your insurance adjuster, it's not going to look good when you're trying to get the sympathy of a jury. If we can ever have jury trials again in California. But I took those things to heart, and I think that's it's important consideration going forward for everyone who's still dealing with their claims.
Well, thank you very much, Eric and Dennis and Joel. So Mark, I might have a hard time reading.
There we go.
We had some questions that came before, so before the event. Uh-oh, my internet connection is unstable. Mark, can you start with the questions that we got before? I like to reward those early birds.
Absolutely, absolutely. And this first question is more forward-looking. I know we've been looking back throughout the presentation, so I appreciate this question. This person lost their home in the Thomas fire and has since rebuilt. They had questions on determining the appropriate amount of insurance coverage. Thus far, they've been able to renew their policy, but they're hesitant to increase coverage for fear of being canceled. So it would be helpful to hear from you all on adequately setting limits and that fear of trying to raise those limits right now.
So if I understand the question, so you heard Joel touch briefly on the fact that this is a topic for a whole nother webinar of the problems that a lot of people in WUI areas and rural and suburban areas are having getting dropped. Joel, people keep asking us as sort of a version of that question. Do you recommend? Do you recommend that people not call not peek their head up right now with their insurer or their agent to ask to increase their coverage if they're realizing that they need to do that?
Yeah, I really don't think I really don't think that is a driver in the insurer's decisions right now. They're really looking at the wildfire risk scores and their concentration levels. There are probably some other considerations in there in terms of longevity of the customer or other policies that they don't disclose entirely. I don't think it is about changing your limits per se on an individual policy. I do think because they're looking at concentration levels,
meaning how many customers they have in a given
right, where a single fire would impact that group of customers, and what is the total amount of limits in play for the insurer. And of course, whatever your limit is on your home, you more or less can double that when you throw in the fact that you have the ALE and the contents, other structures and all. So, there's a lot at risk for every insurer there. But I think people still should seek to be properly covered. I don't think that is going to, raising their hand there isn't going to make them be the one called out for non-renewal. It's other considerations going on behind the scenes. I'd probably be more worried about filing a claim. And one thing we advise people is, you might want to have a pretty significant deductible, because you really don't want to file a $500 claim, or maybe $1,000 claim. If you can afford to pay for those losses yourself, you should try to have a higher deductible limit and not use your homeowner's policy unless you absolutely have to.
Yeah, we actually just sent out, so for all of you who are listening, if you aren't signed up to get our tips of the month from United Policyholders, you should email info@uphelp.org and get added, because we we just put a tip out yesterday, and we talked about this exact thing, that experts recommend that you carry the highest deductible you feel comfortable with, avoid filing small claims, and that's the better way to keep your coverage up without the price being too painful. But it is a big issue. And again, on our website, we have a publication called Drop by Your Insurer in California, Where to Go for Help, and all kinds of other stuff. Mark, you want to read the next question?
Sure. So these next folks, they obtained a new fire policy before a fire that destroyed everything in 2017. They still have quite a bit of ample ALE coverage available, but they are now being evicted by their insurance carrier due to being underfunded for rebuilding and during the rebuilding process. So they sent a letter to the Department of Insurance, and the letter they received back from the Department of Insurance basically outlines that they're not required, the insurer was not required to participate in mediating an issue involving payments beyond policy limits. So the question for the panel was, any tips or advice on helping them with their underinsurance claim, or any comments about voluntary versus involuntary mediation?
Well, anyone want to tackle this? All right, I'll tackle it. So the department has a mediation program that is free, and you can go on their website and you can request to participate. You know, as much as I love Joel, I'm going to say that we hear mixed reviews of the process, because it's like everything else. The quality of the mediator makes the biggest difference in terms of whether you know, whether the mediator just sides with the insurance company and gangs up on you, or whether they're actually a professional neutral that that will really hear you or even try to help you. Because obviously, when you go into a situation like that, you know, if you're just a regular person, you may never have been involved in a lawsuit or a mediation, whereas the person that's representing the insurance company is probably very experienced in that kind of a forum. So, you know, we do that. We think, I love the idea of free services to the public, and a process that that is you have nothing to lose. But it is it's a, you know, certainly for if you have an underinsurance situation, just going into a mediation by yourself, very unlikely that you're going to get much movement unless you have the kind of evidence that we were talking about earlier. You know, that some sort of documentation that you reasonably believed that the insurance company had paid attention to insuring your asset, and that you have reasons why you believe that. But otherwise, I think it's pretty tough to try to settle an underinsurance claim in a DOI mediation. Now, if you're already in a lawsuit with a lawyer, 99% of cases these days do go through a mediation before they get to trial. The courts are obviously, they always look for ways to try to resolve cases before they have to go through the whole process of a trial. So mediation is very common, but it's most successful when you have a good lawyer who takes you through and who prepares and who's done a mediation brief and who takes it very seriously. Next question.
That kind of ties into the next question. One of the last things you said with having that paper trail, these next folks were underinsured substantially, almost 350%. And they pointed it out, numerous mistakes, features, build quantity of their home after they realized this. And it seems like on more than one occasion asked their insurer to come back and properly insure their home. As I mentioned, they identified the mistakes on multiple situations. Frustrated, they did end up sending a request to the Department of Insurance, which remains under review. And during that time, the insurer reached out with a willingness to mediate instead of denying that mediation. They did ask, they receive the letter reassessing that its calculation, telling them they would only entertain an offer from them, from the homeowner, should they make one. So the first question was, how might policyholders develop and make a settlement offer to their insurer without prejudicing themselves if they later needed to file a lawsuit?
Eric, you want to take that? Are you on mute?
It's a big question. In terms of the, I guess in terms of the process, how I would couch that to make sure I wasn't prejudicing is I would make sure that the communication indicated that it is a privileged settlement communication, and that it is not something that you're willing to use or that you expect to be used against you in later litigation. That's very commonplace in all negotiations, in my experience, where people make offers and there's negotiations that ensue with the expectation that it's not going to come back to bite you, because otherwise, under public policy, people would never try to negotiate. And that's how I would approach that, is just to make sure that, and the way that the lawyers do it is typically if we have a communication, we indicate very prominently, whether it's an email or a letter, that this is a communication being sent under Evidence Code section 1152, which basically protects settlement communications. I hope that answers the question.
Yeah, okay. Mark, next.
So they also asked, and this is ties into the last question as well, is it realistic for policyholders to mediate their disputes without being represented by legal counsel?
Yeah, I mean, that was kind of the subtext, I think, of some of the other questions. And I think it really does depend. I think for underinsurance situations, again, if you have good evidence, then, you can certainly take a shot with what Erik's advice, that you have a written agreement in advance that it's going to be a confidential communication. And I know if you go through the Department of Insurance process, you have to agree to that confidentiality. Again, though, because underinsurance is such a tough nut to crack for the individual, and you've heard a lot of our solutions today have revolved around getting together with other people who are similarly situated, or using some kind of leverage that you have, such as my neighbor had better coverage, but we went with the same agent. Why did I have worse coverage? That kind of leverage. If you have that, I always recommend that you confer with lawyers that do work on contingency, so they're not going to charge you by the hour. And you can get an honest assessment from one of the lawyers in our Find Help directory. Almost every single one of them works on contingency. So you can call any of them and say, here's my situation. Here are the facts that I think are strong for me. Would you take my case? And hear what they have to say. And at least, if they say, I don't know if I would or not, say to them, well, I would like to take a crack at a mediation. What do you think what are my strongest arguments, and hear them out. Because lawyers that work on contingency, they don't get paid unless you win or they settle for you. Your interests are aligned with a lawyer that works on contingency in a way that your interests are not aligned with a lawyer who works hourly. Because obviously somebody who's working hourly, they get paid the more time they put in. And so, it's a little, I'm not saying it's always bad. I mean, lots and lots and lots of businesses hire lawyers by the hour, but if you are a consumer, if you're a policyholder, you're a wildfire survivor, there's no reason to hire a lawyer on an hourly basis to go after an insurance company, because there are many good lawyers that will do it on contingency. They have the same interest you have in getting it resolved quickly for a decent amount of money. So they will give you a free assessment of your situation generally, and you can decide, do I want to take a crack at this? But again, I think, the insurance companies, we've been coming at them now for almost 30 years with our saying, you got to fix this. You guys keep on chronically underinsuring people. They have built some pretty strong defenses. They have really, that's why we say, if they give you a questionnaire, you should talk to somebody before you fill it out. Talk to somebody who either got a settlement with, you know, somebody like one of the people that Erik helped in his neighborhood, or that, you know, some volunteers that our organization has, or talk to a lawyer, because again, it's a pitched battle, the battle about overinsurance. And so you just, you know, you don't take a knife to a gunfight, they say. There's got to be a better expression than that. But the point is, like, you know, don't just go in with thinking that you're going to tug on the mediator's heartstrings and they're going to get the insurance company to open up their wallet. That's not going to happen unless you have a pretty good arguments and some evidence on your side, because of what we explained about the law not reflecting reality, that the courts are typically going to say, you know, the insurer did not undertake a special duty unless you can show that they did, to adequately insure your property as opposed to just insuring it. Next,
Yeah.
oh, sorry.
This is Joel. I was just going to add, you know, at this point in the claim, a consumer may have been back and forth quite a long time with the insurer, and it's looking like there's no movement here if you're underinsured. I think it's really important to either bring something new into the discussion, right? So if you're writing that same letter, repeating the same thing that they've already discounted or ignored, you need to find something new to buttress your case or move to a different approach. So, you know, finding out maybe another contractor's bid that shows that your contractor's bid for building your home is reasonable, you know, something that supports, you know, that cost, or maybe a neighbor who had a similar home and had a different estimate of replacement costs than you did with that same insurer, something that you can find through networking with your neighborhood and people in the same situation, or who have been through it and settled their claim. How did they get through to get the additional funds? Because if you're just going to repeat the same comments and facts, and presumably just more angry about it, and Amy already mentioned, try to take that emotion out of it. But if you are repeating the same thing, you know, you'll probably get the same response from the insurer. So you're either going to need to move to mediation or an attorney, or come up with some new arguments that support your case, or go to the department, or do something else.
One important fact to keep in mind is that, as Amy indicated, a lot of these mediations really are they're successful only if, you know, people are prepared and bringing the right information, as Joel alluded to. But it also has a lot to do with the quality of the mediator that's appointed. You know, my results with Department of Insurance mediations are mixed based on those various factors. But keep in mind that even if you don't arrive at a conclusion with your insurance company, and I'm talking about a scenario where you have a withholding of benefits. I'm not talking about a claim that you are trying to get more benefits than what your insurance policy says, but rather you are negotiating with your insurance company about the amount of benefits they're owing. Mediation is a step through the Department of Insurance, which is free. The insurance company actually has to pay for it. You don't. And if that's unsuccessful, don't think that that's the end of the road, however, because insurance policies typically have an appraisal provision that's baked into them, meaning that if you get into a dispute with them, the insurance system does not envision you basically fighting with your insurance company and writing letters forever. And there's a process called appraisal, and you select an appraiser, insurance company selects an appraiser, everybody selects an umpire, and then the umpire makes a decision, and then you get a check. And that's a process that's used all the time. Dennis just got done with one of those claims, and that's basically the end of the road. You get an award, and that's it.
Mm-hmm. Well, okay. I tell you what, we are past the 5:30 mark. We still have a very good amount of people on. I don't want to keep you guys here all night. I want to remind folks we are going to be sending you a survey after today, just to get a little feedback. We are most likely, because we hit our max of 100 registrants and there were more people who wanted to participate, we're going to most likely do a follow-up webinar on the same topic. But we will be sending you a survey. We will ask you to please complete that survey. If we didn't get to your question today, you can email it. I guess we already have the ones that got submitted. So if you submitted them already, we have them. We will do our best to answer them, but along with the survey, we're going to send you a new article that I asked one of our volunteers to write about underinsurance remedies that has an example of one of these surveys that you may be asked to complete. So I just want to give a huge thanks to our panelists. We have Joel, then you can reach Joel at through the department, or I don't know if you can really reach him directly, but you can there's his agency's website and the toll-free number. To reach Erik or Dennis, we've got their information right here. This is Dennis's phone number, and I'm sure you can get to Erik through him. And then you know where we are, uphelp.org. We will be back June 6th with a webinar resolving reconstruction disputes. And that's for those of you who are at loggerheads where your builder is saying my rebuild is going to cost X and the insurance company is saying it's going to cost Y. And you want to, before you go to appraisal, which Erik was just talking about, which is a formal process, a good process if you have a good advocate on your side. It's kind of like an arbitration. But before you go there, you can try this. Sandy Watts, who was an adjuster for 20 years, is now on our team, and she is having some success helping people get their rebuild estimates apples to apples, at least in terms of the quantities of materials and the work that has to be done. So I would encourage you, if that's a problem that's holding you up, you can sign up for that webinar. But again, please complete the survey we're going to send you in a day or two. We will do our best to get you answers to your questions. And again, gentlemen, it's just been such a pleasure to have you with me and to be able to answer people's questions. And to our audience, our hearts and minds are with you, and we know that this is really, when you think things couldn't get worse, and then they did. But you can see there is light at the end of your tunnel, and you will get there. So thank you for being with us, and thanks all of our panelists.
Thank you, Amy, and best wishes to everybody.
All right.
Thanks, Amy. Thanks for doing this.
Okay.